back in 1996 when several of us got together at a meeting in Adana, Turkey, at a conference on human rights and medicine. There was a proposal about some research that some Americans, human rights folks, wanted to do with our Turkish colleagues that didn't seem very productive to me. So I made a counter proposal to do something that I thought was very useful for our Turkish colleagues, which at that time they were submitting alternative reports to the state reports, forensic reports of alleged torture that were dismissed out of hand. And so the idea that I floated was to develop international standards that would compel states to document torture properly, as we were doing at that time as non-governmental organizations, and a framework to judge their evaluations by, because they were completely inadequate. Most of the evaluations by state evaluators in Turkey at that time in 1995, 1996, simply said, no sign of injury or lesion. And that's what was accepted in courts. And so we had this idea, everyone immediately agreed around the table at that time, to go ahead and establish a framework for accountability and to empower civil society to do proper evaluations and to obtain compelling evidence that would corroborate alleged victims' accounts of torture. So, as you know, torture is an act that's usually concealed. It's an act that's committed by or with the acquiescence of state officials. And it's done in secret places, and typically state officials that such things have happened. Hard to get witness testimony, in a secret location after the fact, maybe sometimes weeks, months, years after the alleged torture has taken place. And so to have compelling evidence that would help to prosecute and punish perpetrators is extremely difficult. Clinical evidence, that is physical and psychological evidence of torture, is different because it is in many ways irrefutable. When people have scars and disabilities and can speak about they were tortured and the healing process and the multitude of psychological effects that people can have after torture, that kind of clinical evidence or so-called medical evidence is very compelling, and it breaks through this denial that states often have. And so we understand that the Istanbul Protocol standards has the capacity to break through this cycle of impunity and denial by states. And so it provides justice for survivors of torture, which is critically important, and helps to hold a state accountable for these inhuman practices. I should also say that in the context of asylum, people who are trying to escape their perpetrators, the countries where they were persecuted, when you have a well-founded fear of persecution based on torture or other forms of ill treatment, you can gain a distance from your perpetrators, albeit it's a difficult row to hoe, to start in a new country with a new language, without your job, without your family, and so forth. It helps people establish the facts in terms of the persecution and torture that they experienced to life in a country of asylum. The IP became a global standard through its application around the world. I mean, it was so sorely needed, and it was so fully empowering for health professionals and legal experts to hold states accountable, to have this power that was missing for accountability, that in some ways it flew on its own. It was aerodynamically sound. And so, much to our, great pleasure, we didn't have such high expectations that we would create these norms that would be enduring and that would set people free in some ways from their captors. and to create a distance in the case of asylum from their perpetrators, and so forth. So it's very gratifying to see the way in which the collective efforts of so many people who work every day to be the voice of torture victims. Asylum cases are immediate. I mean, you evaluate someone, it takes several hours, you write up your findings. Again, that takes several hours. Maybe it's 10 hours of time you put in. You're listening to someone who has experienced something quite horrible, and that also feels bad. There are emotional reactions that people have and so forth. And so it's a bit of an ordeal to do an asylum evaluation or any evaluation of alleged torture. And you go to court and you testify, and there is a judge who makes a decision on the spot to grant someone asylum. And then immediately someone's life is changed. And so that happened early on in my career in the early 90s. And it was exhilarating to be a part of justice and to help an individual in that way. And so, that feeling has been repeated over and over again, not just in the context of asylum, but in evaluating people internationally in many different countries, in Supreme Court cases where people win their cases and they obtain some modicum of justice. It's like this. I mean, on a policy level, testifying in the UK Supreme Court fairly recently, where there was a question of whether the Istanbul Protocol should have standing and whether clinicians should be using it in their evaluations. There was a very long process to get to the Supreme Court in a case called Sri Lanka versus KV, and or the Home Ministry versus Sri Lanka KV. And in the end, they decided that the Istanbul Protocol is an important reference point, that clinicians should use these standards to guide their clinical evaluations of alleged torture and ill treatment. When we developed the Istanbul Protocol, what we had in mind was primarily providing guidance in medical legal contexts, right? We didn't anticipate that, in fact, there were no prevention mechanisms like the UN Special Committee on Subcommittee on the Prevention of Torture. It didn't exist. And there are monitoring visits associated with the SPT and their national counterparts, so-called national preventive mechanisms. And so there was a need for one, let's say, abbreviated evaluations for monitoring and prevention visits, as they're called, and in non-clinical contexts, people who come to the ER who suddenly, they have evidence of torture, or they allege that they've been tortured. We realized that there was a need for guidance in these evaluations that take place in non-legal contexts. Also, just providing guidance on legal and clinical evaluations for states and for independent experts does not necessarily change practice in a country where torture is the norm. And there are a multitude of problems. For example, no legal evaluations per se. I mean, in countries where I've worked, for example, in Central Asia, a lot of people are just picked up by police. They're tortured and coerced to make a confession. The police often bribe people. They try to extort money from people on false charges, and that's the way the law enforcement earns a good portion of their salary. It's just the normal practice. So to break through these ingrained torture practices in many countries, there are so many things that need to be done. You can't just simply give guidance to clinicians and expect them to bear the burden of accountability alone. And so we realized, many of us who have tried to implement the Istanbul Protocol in many different countries, it's I would say about 40 now, my colleagues and I have worked in, we've learned that we need to provide the conditions for successful implementation of the Istanbul Protocol. Legislative changes, administrative changes, training judges, having an accountability mechanism where you monitor the evaluations of the state forensic doctors and so forth, changing procedural safeguards to ensure that detainees are not brought back to the place where they alleged their torture and so forth. So we call this implementation, right? And so we, over time, develop guidance on how to implement Istanbul Protocol standards. What are the necessary conditions for those standards? And one of the new chapters in the new edition of the Istanbul Protocol is on IP implementation. I see this in a broader context, that if we are to survive as a species, that we cannot let the intentional infliction of severe physical and mental pain stand. And health professionals, most of all, need to do something about that kind of pain and suffering. It doesn't matter that it doesn't come from disease and injury and so forth, what we're used to seeing in a medical context. It's human suffering, and I think we have a responsibility to prevent and alleviate suffering, regardless of its cause. I don't think of myself as a human rights activist and so forth. I just think of myself as a physician, because I see the pain, the effects of torture and ill treatment and many other human rights violations. And I think that health professionals have a role in identifying the cause and the effects, and holding those responsible accountable. The expectation that we have is that the additional guidance and the original guidance will be integrated into state practices. And I think any state that aims to do something about torture needs to fully implement these standards, including implementation standards and guidance. And I would hope that countries would lead, some countries would lead on that. And this, combined with additional standards on non-coercive interviews, the so-called Mendez principles, which have recently been released and adopted by the High Commissioner for Human Rights, they have a real chance at changing and preventing torture practices. Get involved. The standards are there. It is not your usual type of, clinical practice in some ways. The knowledge is not special in any way. It's like any other medical subspecialty. You acquire knowledge, you begin to the practice through supervision and mentoring. And there are many ways to do this with people who are already doing torture documentation. And it's not that hard. I mean, when we started in the early 90s, there were only 3 of us who were doing evaluations of alleged torture at the time. And now there are dozens, hundreds of people, let's say thousands internationally. And so acquire the knowledge, read the guidance, and get connected with an organization, either a treatment organization or a documentation organization, and learn from people with experience. It's kind of like the feeling that you get with clinical medicine when you really know that you've helped someone reduce their pain, made a diagnosis, given them aid and comfort for what ails them. For the health professionals specifically, the chapters that are most relevant are not the legal chapters 1 and 3, but more so the chapter on ethics, chapter 2, and then chapters 4, 5, and 6 are all about how to interview an individual, uh, what are the physical and psychological effects? How do you document them? And those are critical chapters. The guidance in there is critical for a quality evaluation. Chapters 7 and 8 are the ones that I mentioned. One is on the non-legal contexts for clinical evaluations. And if you're a clinician in one of those situations, you're doing monitoring, prevention visits, and or in an ER, and you come across the possibility of torture, um, that would be a relevant chapter. The implementation chapter is more for the clinicians who are trying to do capacity building in a country where it makes sense to train um, non-governmental clinicians, or perhaps in some instances where there's the government has the political will and the resources and the commitment to really prevent torture and hold perpetrators accountable, to engage, to use the guidance for implementation. That's quite different. Chapter 8 is might be interesting for clinicians, but it's more specific for the sea change that it takes to change torture practices in a country. I just want to reiterate, to encourage clinicians who are interested in this to dive in, to get started, and don't do it um, haphazardly or alone. Work with people who have some experience with this, and be mindful that there is secondary trauma in working with survivors of torture and people who allege torture. Um, it's a very painful experience at times, and there's a lot of literature now on dealing with uh, secondary trauma or vicarious trauma, and so-called countertransference, the emotions that you feel in hearing the traumatic experiences of others. And so uh, when you get involved, please be aware of the very predictable emotional reactions of secondary trauma, and have a plan to mitigate that individually, as an individual, and to be part of a team that also confronts those difficulties from an institutional perspective. So be healthy and take care of one another, and you'll be effective.